Good afternoon once again. This is Dr. Olu Asekun here. Welcome to our podcast. Welcome to my live podcast. Today is another Wednesday. Remember to join us every Wednesday, 12 p.m. Central Standard Time. That is 12 p.m. Dallas time. That is 1 p.m. Eastern Time. And that is 10 a.m. Pacific Time. So, wherever you are in the world, remember to join us. That will be 6 p.m. Nigerian time. Join us every Wednesday. Invite your family and friends. It's a beautiful opportunity to learn about immigration law. It's also a beautiful opportunity for me to continue to answer all the questions you may have regarding United States immigration law. Now, last week we started a series defending a client in removal proceedings. So removal defenses, that was the series we started last week. Last week we discussed EOIR 42B, that is cancellation of removal for non-permanent resident. We talk about the basic requirement that an applicant must have been living in the United States for not less than 10 years, that the applicant must have a U.S. citizen or a permanent resident qualifying relatives, that is parents, spouses, or minor children. We also discussed the fact that the applicant must be a person of good moral character, meaning that there must be no criminal record. So today, we are continuing the removal defenses, and we are still on cancellation of removal. There are actually three types of cancellation of removal. We have cancellation of removal for non-permanent resident. That is the one we discussed last week. We also have cancellation of removal for victims of domestic violence. The requirements are different. We also have cancellation of removal for permanent resident, legal permanent resident. So today, we are discussing the second type of cancellation of removal. That is cancellation of removal for victims of domestic violence. Now, when we talk about domestic violence, those who are familiar with American immigration law, they will be thinking about VAWA. They may think that we are discussing the same thing. Yes, it may be similar, but they are different. VAWA is a victim of abuse too. The cancellation of removal for victims of abuse is also, we are also talking about victims of abuse. However, the requirement of VAWA is different from the requirement of cancellation of removal. So it is very important that we understand that it is not the same thing. For VAWA, an applicant will have to submit Form I-360 with USCIS. It is not the same with removal defenses when talking about cancellation of removal. So in the case of cancellation of removal for victims of abuse, one, before anybody can be eligible for that kind of cancellation of removal, the person must have lived in the U.S. for minimum of 3 years. That is the minimum requirement. Unlike VAWA, where you apply to USCIS. I remember I've represented victims of abuse who have only been in the U.S. for less than a year at the time of filing, and it was still approved. But in the case of cancellation of removal for victims of abuse, such a person will not qualify for cancellation of removal because of the 3-year requirement. And now, talking about the 3 years, it is also important to clarify it because it is not only 3 years in the United States, but it is 3 years before the issuance of the charging document, which is the notice to appear. So, if you have been in the U.S. for only 2 years, and then for some reason an NTA, notice to appear before an immigration court is issued for you, the moment the notice to appear is issued, then it freezes the accruance of physical presence. So meaning that from that moment on, even if you remain in the US for the next 10 years, you will still not qualify for cancellation of removal for victims of abuse, because the issuance of notice to appear will freeze that accruance of physical presence. So it is important to understand that even though, in light of this case was Pereira v. Session, a Supreme Court case where the court has said that an NTA without a proper place, date, and time of hearing is invalid. Well, in view of that, if anybody has an NTA issued, someone who is eligible for cancellation of removal for victims of abuse, if you have an NTA issued that prevented you from being eligible, if that NTA does not have date, time, and place of hearing, you may be eligible to still apply for cancellation of removal as a victim of abuse. Okay, in addition to that, the applicant must also prove, of course, basic things. One, that the marriage was legit, that the applicant and the abuser actually live together as husband and wife. That is a mandatory requirement, because if you don't live with somebody, there will be no opportunity for such a person to abuse you, except in very, very unusual circumstances. I've not done one of such unusual circumstances, but the law make provision for that unusual circumstances. Honestly, I don't know what will make someone qualify for that unusual circumstances, because if you don't live with somebody, it's going to be difficult for such a person to abuse you. But again, it's not impossible to meet the requirement for the unusual circumstances. But in addition to that, the victim must also show. Now, I've listed a few things. One, that the victim must have lived in the US for not less than 3 years before the NTA is issued. Two, that the victim must show evidence that he or she actually lived with the abuser. Three, the victim must now show evidence of abuse. Evidence of abuse. This is very, very important, because what most people consider abuse is actually not abuse. What most people consider abuse is actually not abuse. And what some cultures do not consider abuse is actually what American immigration law considered abuse. Now, because we are discussing American immigration law here today, we are going to be limiting ourselves to the culture here. I mean, there is a saying that when you are in Rome, you have to behave like a Roman. So you cannot be in America and be applying Asian culture or American culture or Islamic culture in determining what constitutes abuse or what does not. So since we are in the United States, we are going to be applying American immigration law. Now, the applicant will have to show that he or she was actually abused. I will develop that further, but I just want to state the basic requirement for now. The last requirement is to also show that the applicant is himself or herself is a person of good moral character. So let me go over it again. The applicant must show that he or she has lived in the US for not less than 3 years before the issuance of NTA. Once the NTA is issued, the accrual of physical presence is frozen. The second requirement, applicant must show that he or she actually lived with the US citizen or legal permanent resident abuser. The third requirement, applicant must show that the abused person actually, the U.S. citizen or permanent resident actually abused him or her. The, the fourth requirement, applicant must show that he or she is actually a person of good moral character. Then the fifth and the final requirement is that applicant must show that removing him or her from the United States will constitute extreme hardship to him. Now, it is very important to understand it. If you look at our previous episode where we have discussed issue of waivers, where we have discussed issue of hardship, even last week when we discussed EOIR 42B, that is cancellation of removal for non-permanent resident, we talk about showing extreme hardship to qualifying relative. Now, in this case of victims of abuse, the applicant is only required to show hardship to himself or herself. This has nothing to do with qualifying relative. The applicant is not even required to have a qualifying relative, unlike other waivers, unlike cancellation of removal for non-permanent resident. In the case of cancellation of removal for non-permanent resident, the applicant is required to have a qualifying relative who is a U.S. citizen or a permanent resident who will suffer extreme hardship if the application is not granted. Now, in this case, the applicant is not required at all to even have a qualifying relative, talk less of proving any extreme hardship to any qualifying relative. The applicant is only required to rely on his or her own hardship, the hardship that he or she will suffer if he or she were to be removed from the United States. So this is very clear and it's very different from cancellation of removal for non-permanent resident. Now, talking about abuse, I said that I'm going to expatiate on that. While I'm doing this, I want to encourage you to start sending in your questions so that once we start answering questions, it will be non-stop. So please send in your question. Our numbers again, we have a dedicated number for questions. For this purpose, the number is 817-883-4495. 817-883-4495. The number is also displayed on the screen. You can send in your question by text. You can send the question by WhatsApp. You can send the question even by calling in. You can also dial the number and call in to ask the question. You can send in all your questions. Please also remember to invite family and friends so that you don't monopolize this information, this free information. It is always good to share the information. As you are enjoying the free service, it's also good to share with others. So remember to subscribe to our channels so that when we go live like this, you will be notified. Now, talking about what constitutes abuse, I've seen all kinds of stories that actually does not amount to abuse. One thing is very clear when we are discussing this issue of victims of abuse. The law does not require that a marriage must work. Even when two American citizens get married, even apart from American citizens, all over the world, people have difficulties in their marriage. People have challenges in their marriage. Marriage is a very, very difficult and complex institution. So it is not everything that happens in a marriage that constitutes abuse. Let me give you some specific examples. You have a spouse who drinks a lot. Every time he will go to club, drink to stupor, come home at midnight and sleep, or maybe sometimes fall into the gutter along the way, get himself, messed up. Is that an abuse? The answer is no. It's not an abuse. That's his problem. That's his life. If you don't like it, that's why there is divorce court. You can go ahead and file for divorce if you don't like that lifestyle. That does not constitute an abuse. It only becomes an abuse if, when he or she is drunk, he now took some additional steps. Maybe after getting drunk, decided to give you a dirty slap, or decide to smack you for questioning him or her, where are you coming from and all that. Then from that moment, it becomes an abuse. But if the act or action is merely that the guy drinks a lot, and that's not an abuse. He has the right to do whatever he chooses with his life or with her life. So if you don't like it, go ahead and file for divorce. So if you are thinking of applying for cancellation of removal as a victim of abuse, that does not constitute an abuse. Let me give you another example, because I've seen all these stories, and I continue to see it all the time. Oh, my spouse cheats on me. Oh, I caught him dating another woman or sleeping with another guy and all of that. Again, that does not constitute an abuse. That's his life. If he or she decide to cheat on you, you don't like it, go ahead and file for divorce. But that's not an abuse. He or she has the right to do whatever he or she likes with his or her body. That does not constitute an abuse. So if you are presenting cases like that, I can assure you that does not constitute an abuse. Now, it may lead to an abuse if maybe you caught him or her cheating, and then maybe that led to an argument, and then that resulted in you being kicked or hit or something. Yes, that's a different ball game. But if it is mere fact that he or she is cheating on you, that does not constitute an abuse. So it is very, very important that we understand that as we proceed. Keep the questions coming so that we don't spend a whole lot of time explaining. I always love to answer specific questions, because we may spend a lot of time explaining and the explanation may not address some specific questions. So it is better, if you have your specific questions, send them in. Keep the questions coming. So today, we are discussing cancellation of removal for victims of abuse. Cancellation of removal for victims of abuse. That is different from the one we discussed last week. The one we discussed last week was about cancellation of removal for non-permanent resident. Even though victims of abuse too are likely to be non-permanent resident, but the cancellation of removal for victims of abuse has different requirements from the cancellation of removal for non-permanent resident. For cancellation of removal for non-permanent resident, the requirements are only 3. The applicant must have resided in the U.S. for not less than 10 years. The applicant must have a U.S. citizen or permanent resident qualifying relative who will suffer extreme hardship if the application is not granted. And thirdly, the applicant must be a person of good moral character. That is the only 3 requirements when it comes to cancellation of removal for non-permanent resident. But today, for cancellation of removal for victims of abuse, the requirements are 5. They are different from the cancellation of removal for non-permanent resident. They are separate 5 requirements. 1, the applicant must have lived in the U.S. for at least 3 years before 3 years prior to the issuance of NTA, prior to the issuance of the charging document, that is the notice to appear. So the applicant must have lived in the U.S. for not less than 3 years. Secondly, the applicant must show that he or she is living with the U.S. citizen or permanent resident abuser. The applicant must show evidence that they are living together, they live together. And three, the applicant must show evidence that he or she was abused by the U.S. citizen or permanent resident spouse. And four, the applicant must show that he or she is a person of good moral character, meaning that there is no criminal record. And finally, the applicant must show that removing him or her from the United States, not approving the cancellation of removal, will constitute hardship to him or her. There is no requirement of qualifying relative. There is no requirement of showing extreme hardship to the qualifying relative. The applicant is only required to show extreme hardship to himself or to herself. So that is what makes the difference between the two cancellation of removals. And of course, the applicant is not required to have lived in the US for 10 years. So those are basic differences in the two types of cancellation of removal. And of course, we are discussing the removal defenses. These are not applications that are processed by USCIS. These are applications that are processed by EOIR, Executive Office of Immigration Review. So we are talking about immigration court now. We are talking about removal defenses, or what we used to call deportation defenses. So we are only talking about people who are already in removal proceedings. We are not talking of anyone who has not been charged to court to appear and explain why he or she should not be removed. We are only talking about removal defenses in this series that is starting today. Okay, questions are beginning to come in, so let's go on. What is the difference between affirmative VAWA and cancellation of removal based on VAWA? I'm sure probably whoever wrote this maybe was typing it before I explain it. I already answered that question, but I will again talking about affirmative VAWA. Affirmative VAWA is filed with USCIS. Cancellation of removal for victims of abuse is not filed with USCIS. It is filed with the immigration court. It is filed with the immigration court. In other words, the applicant must have been in removal proceedings before you can apply for cancellation of removal for victims of abuse. That is the first difference. The second difference, for victims of affirmative VAWA with USCIS, there is no restriction of how long the applicant must have been in the US. In other words, you can enter the US last year, get married to a US citizen, or even maybe you came in as a spouse of a US citizen, and then within 1 year, the applicant started, the US citizen started abusing you. So you could apply for VAWA, affirmative VAWA, within 1 year, even within 6 months, if you have the evidence. So there is no duration. There is no durational requirement. There's no duration that you must have been in the US for X number of years before you can be eligible. However, for victims of abuse who are applying for cancellation of removal at immigration court, you must have lived in the US for at least minimum 3 years before the date of the NTA. So even if you have lived in the US for 5 years, 10 years, if the NTA, the notice to appear, was issued before your 3rd year, you are not eligible for cancellation of removal as a victim of violence. So that is one major, that is additional difference. 4, in the case of affirmative VAWA, you don't need to prove hardship either to yourself or to any qualifying relative. You only need to show evidence that you have been abused, and you show that you are a person of good moral character. For as long as you enter the United States legally, you can adjust your status to that of legal permanent resident once the VAWA petition is approved. But that is not the case with cancellation of removal as a victim of abuse. So for cancellation of removal, you must have lived in the US for 3 years prior to the issuance of NTA. So it's a mandatory requirement. 4, you must show that you have to show evidence of hardship. You have to show evidence of hardship to yourself. In the case of VAWA, you don't need to show any evidence of hardship. But in the case of cancellation of removal for victims of abuse, you have to show hardship. So it is not enough to show that you are abused. You may show that you are abused and still not be approved. You may show that you are abused. You may show that you are a person of good moral character, but you may not meet all the other requirements. So for affirmative VAWA, there are only two requirements: evidence of abuse, of course, evidence of your legitimate marriage, evidence of abuse, and evidence that you are a person of good moral character. But in the case of cancellation of removal for victims of abuse, even if you have those three, that is evidence of legitimate marriage, evidence of abuse, and evidence of good moral character, so you may have those three and still be denied, because one, you still have to show that you have been living in the US for at least 3 years before the notice to appear. Two, you still have to show that not approving that application will cause hardship to you, extreme hardship to you. So the requirements are different. So I hope the person who sent in this question understand the difference between the two types of abuse. Next question. Is there a timeline after the divorce on when I can file VAWA, cancellation of removal? Well, this is a very tricky question. For affirmative VAWA, yes, there is a timeline. 2 years after divorce, you are no longer eligible for VAWA. But again, that requirement is not in the cancellation of removal for victims of abuse. It is not in the cancellation of removal for victim of abuse. So because, like I said, for victims of abuse, you apply in court. So you face the judge. How long you have been divorced is not a requirement in court. But if you file your VAWA with USCIS, you will not be eligible if you have been divorced for 2 years. Next question. My parent is a US citizen and was physically abusive to me, even put me in the hospital one time. Is VAWA only for someone that was married to the abuser? No. VAWA is not for only someone who is married to an abuser. However, if you are talking of yourself as a victim of abuse, you must be a minor. You must be a minor, because VAWA is for spouses of US citizen or permanent resident, or parent of the abuser. So if you are going to be a victim as a child as opposed to parent, you must be a minor child. You cannot be an adult child. So for adult child, no, you will not qualify for VAWA based on abuse from your parents. The moment you are an adult, you are expected to be able to take care of yourself. You can move away from the abuser. But a minor child may not be able to do that. Next question. Will I qualify for VAWA cancellation of removal if my abuser is on F1 visa? No, sir, or no, ma. I don't know if it's a man or woman. No. This is only for victims of abuse based on marriage to a United States citizen or a legal permanent resident. No, it is not for someone on F1, no. However, having said that, if the person on F1 committed a crime against you, if you are a victim of a crime, if you are a victim of criminal activity, that will have nothing to do with the nationality. That will have nothing to do with the legal status of the abuser. Whether the abuser is a US citizen, is a foreigner, or even an illegal alien, that will not matter. if you are a victim, but that will no longer be VAWA. That will be what is called U visa. You will be a victim of abuse. So that is completely different. But for VAWA, the abuser must be a U.S. citizen or a legal permanent resident. Next question. I came in on a K1 fiancé visa but did not get married due to severe physical violence from my USA fiancé. We lived together though. I was put into proceedings because we did not get married and I overstayed. Can I apply for VAWA cancellation of removal? Yes, cancellation of removal, VAWA cancellation of removal is available to fiancé of a U.S. citizen. Yes. However, having said that, you have to go back to the requirement, because if you came in on a K1 visa, the question is, how long were you in the US before the NTA was issued? If you don't meet the 3-year requirement, you will not be eligible. So you still have to meet the requirement. So it is not, that is why we keep saying that immigration is not a one-cap-fits-all. It's not something we just tell you yes or no and then you just go ahead, and there may be different things, different issues that determines eligibility. So in this case, the fact that you came in with a K1 visa will not disqualify you, because K1 visa applicant or K1 visa holders are eligible for VAWA. However, because you have been placed in removal proceedings, that means NTA must have been issued. So the first determining factor is to go back to look at the date on the NTA. So the date the NTA was issued, on that day, have you been in the US for 3 years? If the answer is yes, then you will be eligible for cancellation of removal for victims of abuse. But if you have not been here for 3 years, you will not be eligible for cancellation of removal for victims of abuse. But you may still be eligible for regular affirmative VAWA, even though you are already in removal proceedings. So it is better to consult with an experienced immigration attorney who will look into your specific case and advise you accordingly. But yes, the fact that you came in on K1 does not prevent you from eligibility if you meet the other conditions. Next question. Please keep the questions coming in. Keep the questions coming in. Next question. What are examples of extreme hardship for a person? How do we prove this? Well, like I said, immigration is not a one-cap-fits-all. What may constitute hardship to you may not constitute hardship to another person. There are different things that constitute hardship. For example, if you are looking at hardship, you look at medical condition, especially if that condition was created by the abuse. That is a major factor. For example, let's say you are married to a U.S. citizen who inflicted some physical harm on your body that requires you to receive medical attention. Of course, if you can show that getting quality medical treatment from your home country will be difficult, will not be as easy as in the United States, that will constitute extreme hardship, especially if you cannot afford it, because here in the United States, victims of abuse are actually allowed to obtain public charge. In other words, if you are a victim of abuse, you could obtain public charge. Things that ordinarily foreigners cannot do, you may be able to do it if you are a victim of abuse. So you can go to the hospital and apply that the government pay the bills. Of course, if you have to go back to your home country and you cannot afford to pay for the treatment because of the effect of something that was caused by the abuse, yes, that will constitute extreme hardship. So financial consideration will be taken into consideration. Political stability, the condition in a foreign country will be taken into consideration. If you have children who you are taking care of, who are US citizens, and you don't want to take them along with you, and you don't want to be separated from them, that will also constitute extreme hardship. I mean, there are lots and lots of things that will be considered. But again, you don't even need to show extreme hardship to other people. You only need to show it to yourself. And of course, like I said, you can look into situation in a foreign country. You can look at economic factors. You can look at social factors. You can look at health factors, a lot of other things that ordinarily they don't allow for people who have to show extreme hardship to qualifying relative. The next question, there are some noises there. Somebody making noise. The next question, I'm a victim of psychological abuse by my husband and I'm in removal proceedings. Does this type of abuse make me qualify? Well, I've said it over and over. Immigration is not a one cap fits all. So I don't understand what you mean by psychological abuse. Psychological is a very big word, and it's an open-ended statement. So it's not something that I can tell you whether yes or no. But what one thing I will tell you is that when we are talking about abuse, abuse could be physical, abuse could be emotional, abuse could be psychological, abuse could be manipulative. So it is not limited to physical beating or physical harm. So if that is the angle your question is addressing, the answer is yes. Abuse does not necessarily have to be physical, but more importantly, it has to be manipulative. Next question. I had a green card, but it was rescinded and I'm now in removal proceedings. If I otherwise qualify, can I apply for VAWA cancellation of removal? Yes, the answer is yes. If you are otherwise qualified, yes, because once your green card is rescinded, it puts you back in the status you are in before the green card was approved. So whatever status you are in before the green card was approved, that is the status you will go back into. So if, for example, you are on visiting status before your green card was approved, once the green card was rescinded, you go back to visiting status. So anything that someone in a visiting status could apply for, yes, you could apply for it. The only difference is that because your green card was rescinded, the judge or whoever is going to be the adjudicator will probably take that into consideration when determining whether you are a person of good moral character, because that is one area where discretion comes in. So those factors may be considered, but it's not a legal requirement. Yes, you may be eligible if you meet other requirements because you will be back to the status that you were before the green card was rescinded. So let's see other questions. Okay, the next question. What happens if I have criminal conviction for an aggravated felony for committing fraud? Can I still apply if I have all the requirements? Well, if you are convicted of aggravated felony, there's no way you can have all the requirements because apparently if you listen to the requirement, you will know that you are not eligible because I stated 5 requirements. You must have lived in the US for not less than 3 years before the NTA was issued. You must have been married to a US citizen and your marriage, you must have lived together as husband and wife, because if you don't live with somebody, that person will not have the opportunity to abuse you. 3, you must have been abused by this U.S. citizen or legal permanent resident. And 4, you must show extreme hardship to yourself if you are to be removed from the United States. And 5, finally, which is where you will not meet the requirement, you must show that you are a person of good moral character. So there is no way you will be convicted of aggravated felony and you will still be able to show that you are a person of good moral character. Definitely, you will not meet the requirement. So if you have been convicted of aggravated felony, I have to be honest with you, your reliefs are extremely minor. They are not many. Your reliefs are very, very limited. So what I'm going to advise you is to consult with an experienced immigration attorney who can look into your specific case and then advise you appropriately. But are you eligible for cancellation of removal for victims of abuse? The answer is no. Even if there is evidence that you are abused, you will still not be eligible because there is no way you can prove that you are a person of good moral character. But of course, you may have other reliefs, so consult an experienced immigration attorney. Next question. Once the application is filed with the court, can I get work permit? Yes, if you are eligible for cancellation of removal for victims of abuse, yes. If you file your application in court and you file adjustment application along with it, yes, you can. If your application is accepted and file stamped, date stamped by EOIR, yes, you can use that to apply for employment authorization. But it depends on whether your case is detained or not, because if it's a detained case, your hearing may have been completed even before your EAD is processed. So it's not, there is no easy answer to most of these questions because it's not a one-car-fit-all scenario. But the general rule is that, yes, you will be able to get employment authorization. That is the general rule. But whether you will actually get it or not depends on a whole lot of other extraneous factors. But are you going to be eligible? The answer is yes. Now, next question. Hold on a minute, just a second. Okay, next question. Hello, this question is about cancellation of removal, but not abuse. I was granted cancellation of removal by the IJ. I have not received my green card and it has been a year. What can I do? Well, if you have been granted cancellation of removal by the IJ, the day your application was granted, that is the day you became a legal permanent resident. So if it was granted a year ago, like you said, it means that you have been a legal permanent resident since 1 year ago. So there are a few things you need to note. One, for the purpose of becoming a U.S. citizen, you started counting it from a year ago. Now, if you are married to a U.S. citizen, that means that from the date your cancellation was granted, you are only required to be a permanent resident for 3 years. So you don't need to have the physical card in your hand. The date the immigration granted your cancellation of removal, you became a permanent resident on that day. And for the purpose of citizenship, you start counting from that day. So, which means in your case, you have 2 more years to go. 2, what you can do, call USCIS and schedule an InfoPass appointment. Schedule an InfoPass appointment. So when you schedule an InfoPass appointment, make sure you attend your appointment with your passport, with your international passport, and then the court order granting you cancellation of removal. So if you do that, then when you get to your appointment, they will stamp your passport to show that you are a legal permanent resident, and you can use that stamp either for employment or even for travel purpose. You can use it to go in and out of the United States. The third thing, you can, if you have a lawyer represented you, your lawyer can contact Office of Chief Counsel. So your lawyer can follow up with the Office of Chief Counsel, and then also your lawyer can also do an info pass appointment on your behalf. So you have all these multiple ways to follow it up, but more importantly, get your passport stamped. That will show evidence of your permanent residency, and you'll be able to go in and out of the country while waiting for the physical green card. And of course, for the purpose of citizenship, you start counting from the date that your cancellation of removal was granted. Next question. Hello, sir. You have mentioned relief a few times, but I'm sorry, I'm not understanding you. What does relief mean for immigration court? Okay. We have actually explained this in previous podcasts, but I will go ahead and explain it again. Now, the way it works is that when you are placed in removal proceedings, there is something called charging document. Immigration proceedings is not a criminal case. It is different from a criminal case. But I'm going to use a criminal case to explain it. In a criminal case, when somebody is accused of a crime, they charge the person to court. So the charging document will state what the crime is. You so and so person, you committed a felony by stealing $10,000 from ABC in violation of section something of the criminal code. That is the charging document in immigration in criminal cases. In the same vein, we have a charging document in immigration case, but immigration is not a criminal matter, it's a civil matter. So we have a charging document. So that charging document is what will determine, is what will tell you what the allegations against you are. That charging document is what is called NTA, Notice to Appear. That is what will tell you what the issues are. So usually the charging document will have about 4 or 5 allegations. Allegation 1, you are not a citizen of the United States. Allegation 2, you are a citizen of so country. Allegation 3, you entered the United States on so date with authorization to remain until so date. Allegation 4, you remain in the United States beyond so date. That is just a sample. Every NTA is not the same. Some NTA, you may have entered the US as an immigrant. Some NTA, you may have entered the US as an arriving alien. Some NTA, you may have entered the US EOIR. EOIR means entry without inspection. So NTAs will generally tell you what the allegations against you are. Now, when you appear before an immigration court, the judge will ask you, did you receive the NTA? You have to answer yes or no. If you receive it, you will tell the judge. If you didn't receive it, the judge will turn to the government lawyer to provide another copy to you. So the judge will ask you, now have a look at these allegations. How do you want to plead to the allegations? If you look at the examples that I gave you, most of the time it is always difficult to challenge the allegation in the NTA because immigration is so smart that they formulate these charges in a way that you will not be able to deny them. If an NTA says you are not a citizen of the United States, that is a fact. You can't deny that. Let's say you came into the US with a Mexican passport. The NTA says you are a citizen of Mexico. You can't deny that because you came in with a Mexican passport, so there's nothing to deny. Let's say when you came in, you were given 6 months at the port of entry. The NTA says you are admitted with authorization to remain until so time. You remain beyond that period. How are you going to deny that? So you are not going to be able to deny most of the charges. So now, you'll be forced to admit the allegations. So when you admit the allegations, then the judge will conclude that the removal against you has been established. So what that means is that the government has met its burden. Now, in a criminal case, I'm still using this example. In a criminal case, the burden of proof is on the prosecutor. The burden of proof is on the government, and the burden is beyond all reasonable doubt. In immigration case, because it is not a criminal proceedings, the burden is not beyond reasonable doubt. The burden in an NTA is clear and convincing evidence. So once you admit the allegations, then the judge will conclude that the government has met its burden, that removal has been established by clear and convincing evidence. Now, once that is established, the burden shifts to you. In a criminal case, burden does not shift to the accused person. Under no circumstances will burden shift to the accused person in a criminal case. But in immigration proceedings, once the government has met the burden imposed by the NTA, then the burden shifts to you to tell the judge, the immigration court, why they should not remove you from the United States. So that it is at that stage that the judge will ask you, what relief are you seeking? So it simply means that, why should we tell us why you should not be removed? Tell the court why this court should not order you to be removed back to your home country. So what relief are you seeking? So when we are talking about relief, we are talking about the reason why the court should not order you removed from the United States. So that is what relief in immigration case, that is what it means. So I hope it's very clear now. Next question. I was a victim of abuse, but my children were not living with me at the time of the abuse. I'm currently in removal proceedings. Can I include my children in my application? Yes, your children does not necessarily have to be victims of abuse for them to be eligible for relief if they were placed in removal proceedings as you. Remember, if you are talking about cancellation of removal, it means that you are already in removal proceedings. So the first question is, are your children placed in removal proceedings? If they are not, there is no way you can include them, because you are the one in removal proceedings. You are the one that will have to carry your cross. But if your children were listed as a rider in your NTA, if your children were simultaneously placed in removal proceedings as you, or even subsequently placed in removal proceedings as you, for as long as your children are in removal proceedings, yes, you can include your children. It doesn't matter whether they were living with you at the time of the abuse or not. What is important is that you are the parent, and you are the one that was abused, and your children are minor. Those are the things that are important. But again, if your children are not placed in removal proceedings, then they will not be able to benefit from this. But if you become a permanent resident or maybe a U.S. citizen, you may be able to petition for your children, depending on their age. If you become a permanent resident while they are still under 18, you may be able to petition for them even if they are out of status. But if they are 18 and above, then you probably have to wait until you become a citizen, because a permanent resident who petitioned for someone, including children, the beneficiary must show legal status at every point before the adjustment application is filed. So if they met those conditions, you may be able to petition for them. Let's go to the next question. I was told to go see one psychologist for my case, but I had mental health issues before, and I'm scared to go. because my spouse told everyone I was crazy. Could it be used against me? Well, I'm not sure I understand this question, but I mean, if one, I don't even know who told you to go and see a psychologist. I don't know why. I mean, there are a lot of things that are not clear here. I don't want to. I don't want to assume that I understand the question. But one thing is, if you had mental health issues, it's not it's not a requirement. That by itself does not disqualify you. Does not disqualify you. But of course, depending on the specific fact of your case, if, for example, your mental health issue will exonerate your spouse from the allegation of abuse, yes, that can be a factor. For example, if you behave in a way that your spouse was forced to physically restrain you, you cannot consider that as an abuse. Yes, the court will look at that to conclude that you are not abused. But the good thing here, which may work in your favor, is that usually most of these cases do not involve the abuser. So your husband is not going to be in court to testify. It's not as if they are going to be cross-examining your husband. What happened? Why did you restrain her? So even if you were acting erratically and he or she had to physically restrain you, because he or she is not going to be part of the proceedings, that information may not come out to the court. But again, if there are documentary information in your record to show your pattern of behavior or to show things that will warrant your spouse to physically restrain you or do other things to ensure that you don't get out of control, yes, those things may be factors in determining whether you are actually a victim of abuse or not. But again, I'm going to advise you to consult an experienced immigration attorney who can actually consider the totality of your situation and come up with a very good defense for you. Because to be honest with you, even for you to face removal proceedings, if you have mental health issues, the court will first determine, the court will first make a determination that you have legal capacity to face trial. That is that will be the starting point. So your mental health issue may actually not be a negative thing, because for someone with a mental health issue, again, depending on the lawyer you are using, if you hire an experienced immigration attorney, the first challenge for the court is to determine that you have the legal capacity to face trial. So again, there are so many things that I don't want to be discussing publicly in this type of scenario, but I will tell you, consult an experienced immigration attorney who will look into the peculiarity of your case and then advise you appropriately. Next question. When I came into the US, I used a fake entry permit. I was admitted, but eventually I was convicted of this offense. Will this exclude me from being able to apply for any cancellation of removal? Well, you didn't provide enough information for me to really answer this question one way or the other, because I don't know what led to the conviction. Were you arrested at the port of entry, or was this an event that happened subsequently? At what point were you placed in removal proceedings? At what point? I mean, there are so many things that I don't know. Honestly, with this type of question, I will advise maybe either you clarify it if you want, or you can actually request a private consultation on this, because I don't want to speculate and I don't have enough to answer the question one way or the other. So even if you are convicted of the offense, I will need to see the charging document, the conviction document. What were you charged for? Was it a federal crime? Was it a state crime? Was it a crime of moral turpitude, or your conviction? Was it something that constitutes aggravated felony? Was it something under that? What is a regular felony? What about your situation? Do you have a qualifying relative? I mean, there are so many things. There are so many unknowns. So it's not going to be easy for me to just tell you, yes, you will be able to do this, or no, you will be. It's not going to be easy. So I will need more information. Next question. Please continue to send in your question and remember to invite family and friends every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. Remember to invite your family and friends. We do this every Wednesday. It is free of charge. As you can see, you have the opportunity to ask questions, and we will answer your questions in great detail as much as we can, and this is free. So it will be unfair for you to be monopolizing this type of information. Share with your friends, share with your family, subscribe to our channel so that once we go live, you will also be notified. And before I go on, in addition, I want to say that in our office here, we handle personal injury claims. If you have been involved in an accident that is not your fault, please call our office. For that purpose, you can call our regular lines, 817-891-6655. You can call 817-274-1144, extension 602. You can call 817-274-1844, extension 603. You can also call this line 817-883-4499 for assistance. We can help you to claim some benefit from the insurance company. So just passing that information across. Now, next question. I was already ordered removed. Can I still apply for cancellation of removal for victims of violence? Well, again, this is not a question I can say yes or no, but I can tell you, if you have been ordered removed, it is unlikely that you will be allowed to apply for cancellation of removal. But at the same time, I'm not ruling it out, because immigration law is so complicated. It is so complicated. It is not a one cap fits all. There may be one little thing. There may be one little thing that makes a big difference in your case. The first question is, why did your lawyer not present this relief for you before your removal proceedings was over? That is a question I cannot answer. Was it that you didn't tell your lawyer about it, or was it because of what we call ineffective assistance of counsel? If you can show that you actually told your lawyer all of these things, but your lawyer was ineffective, maybe your lawyer didn't know that this relief exists. If you can show that, you may have a relief in the form of ineffective assistance of counsel. We call it matter of Lozada. you may be eligible. I'm not saying you are eligible. I'm just saying you may, because like I said, there are so many things I don't know about this case. Number one, once you have been ordered removed, your case is closed, except if you file an appeal. If you file an appeal within 30 days, then your case goes on an appeal. However, I can tell you for sure and with certainty, you cannot present a new relief on appeal. That is not what appeal courts are for. Appeal court, when you file an appeal, you are saying that you disagree with the decision of the lower court. So it is only what you presented to the lower court that you can argue on appeal. So if this relief was not presented at the immigration court, you cannot go on appeal and present a new relief. So that will not work. Now, if you were ordered removed, you can still file a motion to reopen within 90 days of the time you were ordered removed. But you will have to convince the judge why you did not present that relief at the previous hearing. You have to tell the judge why you didn't, because like I said, after the NTA was, when you plead to the NTA, the judge is going to ask you specifically what relief are you seeking. So it is within your right to mention every single relief that you think you may be eligible for. So if you didn't present this relief, it is unlikely that the judge will grant a motion to reopen. But again, I'm not saying it is impossible. I'm just saying it is unlikely. So every case is different. So again, if you are applying the matter of Lozada ineffective assistance of counsel, then the 90-day deadline will not even apply. So you can still file your motion to reopen, you can still file your motion to reopen even outside of the 90-day deadline, but you cannot present a new relief on appeal. So again, I can't tell you yes or no to your question because there are so many things I don't know. Maybe you will need to do a consultation with an experienced immigration attorney who can actually look into your case and advise you appropriately. Next question. My USCIS spouse was abusive to my child, not myself, but my family. Not myself, but my family and I are now in proceedings. Can we apply for cancellation of removal based on the abuse if we otherwise qualify? Yes, you can, if you have the evidence. Remember, the judge is not going to rely on your statement. Whatever statement you are making must be supported by documentary evidence. So if you have the evidence and you meet other requirements, yes, the abuse could be to you or to your child. Yes, that is very, very correct. Next question. Please keep the questions coming in. Keep the questions coming in. Next question. My case for cancellation of removal was denied by the IJ, but I am appealing the decision. Can I still use my work authorization in the meantime while my appeal is pending? Yes, that's a very straightforward question. The answer is yes. When you are ordered removed, that concludes the case. However, when you file an appeal, it means that the decision is not final. And because we cannot preempt what the decision of the appellate body will be, the judge's decision remains suspended until the appeal is determined. Yes, so whatever employment authorization you have, you can continue to use it. Yes, that is very correct. The answer to that is yes. Next question. Can I use text messages between my abusive spouse and I as evidence of abuse? Well, it may be part of the evidence, but again, it also depends on a number of factors. You see, I keep saying this, and I want you to pay attention to me. immigration law is not a one-cap-fits-all. It is not something that you can say when you multiply 2 times 2, you are going to get 4. When you are dealing with immigration law, you can multiply 2 times 2 and get 4. You can multiply 2 times 2 and get 7. You can multiply 2 times 2 and get 5. You can multiply 2 times 2 and get 9. So immigration is not a one-cap-fits-all. It's a very technical area of law. So when you are talking about establishing evidence, there are series of ways that you can do it. But if you are going to use a text message, the first challenge that you are going to have is to show that the number, you have to establish that the number belongs to your spouse. You have to establish that. And that will be easy for you if you have joint bill, if you have joint phone bills. So your joint phone bill will show who uses the phone number. It will show both of your names. Then the text messages will also show both of those numbers. And let me tell you this, most people, they save their spouse's name by whatever name they call their spouses. Maybe you call your husband Hobby. You save it as Hobby. Maybe you call your husband Dear. You save his or her number as Dear. Or maybe you call your wife whatever name you call. Let me tell you, in the text message, it is Hobby or Dear that is going to show up. So how is immigration or the judge going to know that Dear or that Hobby is actually your husband? Remember, when you are in immigration court, when you are in proceedings, the immigration itself is going to be represented by a lawyer. And you are probably also going to be represented by a lawyer. So most of these things is not going to be, they are just not going to take it for what you want it to be. The immigration lawyer is going to do everything possible to discredit your testimony. So the lawyer is going to point out most of these things that I'm telling you, that look, the fact that there is a text message from one Hobby, that doesn't show that that is your husband. That does not show anything. So for you to establish that, you will first have to show that that number actually belongs to your husband. And one of the best ways to show that is to request for copies of those text messages from the carrier, not relying on your text message or your screenshot. If you rely on your screenshot is going to show that text message came from Hobby, text message came from Dear, or Darling, or so. No, it's not going to prove anything. So it is a little more complicated than that. But again, if text messages supported by corroborative evidence, is it acceptable? Yes, the answer is yes, it is acceptable. But you first have to show that that number where the text messages are coming from actually belong to your spouse. The next question. I'm currently separated from my abuser. Can I file for VAWA cancellation removal if I'm still married to him? Well, you can only file cancellation of removal for victims of abuse if you are in removal proceedings. You can file if you are still married to him, but are you in removal proceedings? If you are not in removal proceedings, you cannot. So if you are not in removal proceedings, you may need to do the affirmative VAWA. But whether you are still married to him or not does not stop you from applying either way. Either you are in removal proceedings or not. Yes, you are not required to continue to stay with somebody who is abusive to you. But if you are currently separated, yes, you can file it. Divorce can come later. Please keep the questions coming. Keep the questions coming. Remember to invite your family and friends. Let them join us every Wednesday, 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific time, and that is 6 p.m. Nigerian time at this time, because time does change here. In the future, it may change, but right now it's 6 p.m. Nigerian time. It's 12 p.m. Dallas time. That is when we start the podcast every Wednesday. Please join us. Invite your friends, invite families. Continue to send in your questions. You can send your questions ahead of time. We try as much as possible to at least notify, to post the topic that we'll discuss ahead of time. So if you have questions regarding the topic, if the question crosses your mind, just pick up your phone, send your questions to our number 817-883-4495. That is our dedicated number for this podcast. So send in your question at any time, even if it is during midnight. Send in the question. When we get to the office, we will see the question, and during the podcast, we will answer your question. So send it ahead of time. Send it live during this program. Invite family, friends, and also remember, we handle personal injury claims. So if you are a victim of a car accident, if you are a victim of a slip and fall, if you are a victim of any form of accident that is not your fault, contact our office and we will help you to ensure that you are appropriately compensated. Remember to call and get in touch with us. Keep sending in your questions. We will continue to do this until 2 p.m. We still have about 44 more minutes to go, so keep sending in your questions. Okay, a question just came in now. Does the court ever issue a request for evidence like USCIS does? After listening, I'm worried that I did not supply enough evidence with my case. If they do not, what can I do? Well, that's a very brilliant question. Well, I actually have answered this question in the course of this podcast, but I will repeat it again. The court is not part of USCIS. The court is not part of the Department of Homeland Security. The Department of Homeland Security is an agency of the government that has 3 sub-agencies under it. Those sub-agencies are USCIS, that is United States Citizenship and Immigration Services. Those are the sub-agency that handles petitions and applications. So whenever you file something, whether you want to file the case in court or not, all payment goes to USCIS for as long as it is immigration related. The court does not accept money. They do not accept payment. So if you are going to file anything in court that requires payment of fees, you have to file it with USCIS. If you want to file any affirmative application, any immigration affirmative application, you have to file with USCIS. Now, USCIS, they have a different law that guides their operation. Part of their law is that if something is known to USCIS that is not known to the petitioner or the applicant, that thing may lead to the denial of the application, USCIS is under a mandatory duty to notify either the applicant or the petitioner, either in the form of request for evidence or notice of intent to deny. So that is the law governing USCIS. Again, USCIS is just one of the sub-agencies under the Department of Homeland Security. We also have CBP, that is Custom and Border Protection Officers. They are the ones that admit people at the borders, either land border, sea border, air border. They are the one that admit people. They are the one that determines how long you stay in the country. They are the CBP officer. The third sub-agency under DHS, that is what is called ICE, Immigration and Customs Enforcement. They are the one that enforce immigration law. They are the one that arrest people. They have ICE police. They are the one that detain people. They also have legal department. Their lawyers are the one that come to court, immigration court, to prosecute respondents. Now, the reason I'm explaining all these things is for you to understand how these things work. Now, when you are in court, a court is an independent body that determines, that adjudicates cases between two warring factions. ICE will bring a case to court telling the court to remove you from the United States. You as a respondent has an obligation to hire your own lawyer to defend yourself. So the court, it is not the duty of the court to tell you what is missing from your case. It is not the duty of the court to, in fact, if the court has to tell you that, oh, you didn't present this, that shows bias. That shows that the court is biased against USCIS. That means that the court is not going to be an independent body. So the court does not intervene in telling one party or the other what evidence to submit to prove their case, or what evidence not to submit. So that is not the duty of the court. So the court is an independent body. The court is not part of the Department of Homeland Security. The court is actually, the immigration court is actually part of the Department of Justice, because it's an administrative proceedings. It is part of the Department of Justice, but it is an independent body. So the court will not tell you what is missing in your case. Now, having said that, you already, I believe you understand my answer to your question. Court does not issue requests for evidence. But having said that, the immigration court, they have rules and procedures, and they have do's and don'ts. There are rules, there are local rules, and there are national rules. So some courts abide only with national rules. Some courts, in addition to the national rules, they have their own local rules. So there are so many factors that has to be considered. So telling you what next to do is something that is going to be difficult for me, because one, I don't know which court you are dealing with. I don't know whether it's a court that uses only the national rules, or it is a court that has its own local rules. Secondly, I don't know how far you are in your removal proceedings. Like I said, there are rules. For example, if you have to submit certain evidence, there is a time limit. There's a time requirement. You have to submit certain things within certain time during a proceeding. So there are so many things that I don't know about your case. So I cannot really effectively advise you on how to proceed. But I do know that if you consult an experienced immigration attorney, they will guide you on how best to proceed. But the court does not issue requests for evidence. Next question. I'm currently in removal proceedings. I was previously married to an abusive LPR. I am remarried now, someone with no status. Can I use my prior marriage for cancellation of removal? No, sir, or no, ma. You cannot. You cannot, because for cancellation of removal as a victim of abuse, the moment you remarry, you are no longer eligible for this relief. So it is a relief that is only available when you are either married to the abused spouse, or you are no longer married, you are divorced from the abused spouse. But the moment you remarry, you remarry another person, you lose the privilege of applying for cancellation of removal, either as a victim of abuse or even VAWA in the affirmative VAWA with USCIS. You have to, in fact, for affirmative VAWA, if you have been divorced for 2 years, you are no longer eligible for affirmative VAWA. That requirement is not in the EOIR requirement, but your remarriage, of course, will prevent you from being eligible for this cancellation of removal. So you cannot. So please keep the question coming in. We still have about 30 more minutes to go. Invite your family and friends, as we stated earlier. It will be unfair for you to receive all this valuable information and keep it to yourself. So you can imagine, if I keep all this knowledge to myself, how are you going to benefit? So if I am magnanimous enough to share this knowledge with you free of charge, it is only fair that you also let your family and friends know that they have the opportunity to benefit from these resources. So the only way to keep us encouraged is by inviting your family and friends. Also, subscribe to our channel, subscribe to our YouTube channel, so that when we go live, you can be notified. By God's grace, we plan to continue doing this at least once every week. That is every Wednesday, 12 p.m. Central Standard Time. That is Dallas time. And that will also be 1 p.m. Eastern Time. That will be 10 a.m. Pacific Time. And that will also be, currently, that will be 6 p.m. Nigerian Time. So all over the world, tune into our channel every Wednesday. Remember to invite family and friends. Also, remember to subscribe to our channel so that will enable you to be notified whenever we go live. And also, we want you to know that we also handle personal injury. So if you are involved in any form of accident, either auto accident, either slip and fall, either any form of accident, and you can contact our office and we will help you to process adequate compensation. So join us every Wednesday again. Keep the questions coming in. Keep the questions coming in. I think I've answered the last. Oh, okay. Oh, I think there are new questions. Okay. Okay, there are new questions. I have an approved VAWA, and I'm in removal proceedings. My hearing is set for 2026. Is there anything that I can do? Of course, if you have an approved VAWA, if you are in removal proceedings, that means that USCIS will not have jurisdiction over your VAWA. So, of course, they are not going to adjudicate your case. But I'm assuming that you have a lawyer representing you in the removal proceedings. There are multiple things you can do. Your lawyer can contact the Office of Chief Counsel, can contact them and provide evidence of your approved VAWA and evidence of your eligibility for adjustment, and then request a joint motion to terminate the removal proceedings so as to give USCIS the jurisdiction to adjudicate your case. That is one thing you can do. Another thing you can do, you can tell your lawyer to file a motion to advance hearing. So if you file a motion to advance hearing, provide evidence that you have an approved VAWA and other evidence of your eligibility for adjustment of status. If you file it, they will advance the hearing. That means they will move forward the hearing from 2026 and they can move it forward to this year. Again, there are other things I don't know about your case. I don't know whether this is a straightforward adjustment. I don't know whether it's a complicated adjustment that requires a waiver, for example. I don't know whether there are going to be issue with eligibility for adjustment. So there are so many things that you didn't say, but I tell you, you can do several things. Talk to your lawyer. I'm sure your lawyer will know what to do. But if he or she does not know what to do, tell your lawyer to do one of those three things that I've mentioned. Your lawyer can file a request with the Office of Chief Counsel and request that the case be terminated so that USCIS will assume jurisdiction. If your lawyer is an immigration attorney, he or she will know how to contact the Office of Chief Counsel. Another thing your lawyer can do is to file a motion to advance hearing. So that means they can bring forward the hearing case and the immigration court can adjudicate your case in court. Again, depending on your situation, if your case is a straightforward adjustment, your lawyer can actually request a WebEx hearing, file a motion to advance hearing and request WebEx individual to adjudicate this case as quickly as possible. Your lawyer can do one of those three things, and I'm sure that you will get your adjustment as quickly as possible. Next question. When I was being abused by my USC spouse, I left our home with nothing but my children and my purse. I do not have a copy of his birth certificate or US passport. How can I prove his citizenship? To be honest with you, I have my doubt about this question. I'm not questioning your marriage. I'm not questioning anything, but I have my doubt. Having said that, I'm going to tell you this. There is no way you'll be married to someone and not have their information. Is it driver license? Is it date of birth? Is it social security? Is it, I mean, that you can't be married to someone and not know your spouse. Immigration have access to use many of these factors to determine one's eligibility, one's legal status. For example, if you are married to somebody, I'm sure that at one point or the other, you must have filed joint tax return. If you have filed joint tax return, the joint tax return will have his or her social security number. If you provide a detailed affidavit to USCIS with his information, date of birth, social security, and all of that, immigration is able to use that information to pull his legal status, to determine his citizenship. But again, there will be lot and lot of other corroborating factors. It is not just the physical paper of a birth certificate alone. It is more of corroborative evidence. Again, this is my opinion. I may be wrong, but I'm not accusing you of anything. But I'm just saying that it's almost impossible for people in a country like the US to be married and not have information about each other. That is highly unlikely. So if you have all of this information that I've mentioned, you can. I have filed VAWA for client in the past where we didn't have access to. We didn't even know whether the client, whether the abuser was a U.S. citizen or a permanent resident. We didn't even have that information. But again, it was still approved because there were corroborative evidence. There was substantial and probative evidence in the record. And that is all that immigration needs in order to make that determination that this person is a U.S. citizen or this person is not a U.S. citizen. But if you need additional clarification, consult an experienced immigration attorney who can actually guide you on what to do. That is as much as I can say on here about this question. Next question. I read online that if I am applying for cancellation of removal based on abuse, it can be granted even if I have lied about being a USC. Is that true? Well, it is not true per se, but it is not also false. Let me tell you this. False claim to USC, when you lie to immigration that you are a US citizen when you are not, that is what is called false claim to USC. False claim to USC does not have a waiver. It is a permanent bar without a waiver. False claim to USC does not have a waiver. That is that. Now, secondly, cancellation of removal did not specifically list false claim as one of the requirements, unlike adjustment of status. Adjustment of status does. If you are applying for adjustment of status and you are falsely claimed to be a US citizen, you are not eligible. But cancellation of removal does not expressly list that as one of the requirements. Now, the issue is the judge who is going to adjudicate your case, in determining that you are a person of good moral character, is the judge going to look at the fact that you are falsely claimed to be a USC? That is something I cannot predetermine. Again, remember, when you are in removal proceedings, you are going to have two lawyers competing. You are going to have one lawyer representing ICE, that is Immigration and Customs Enforcement. That lawyer is going to be pointing out everything that is wrong with your application. You are also going to have your own lawyer who is also going to be defending you. Your own lawyer is going to be pointing out everything that is good about your application. So the ultimate decision lies with the judge. So, number one, if the lawyer representing the government make the issue of false claim to USC, if the lawyer makes it a big issue during the trial, how is the judge going to react on it? That is something that I cannot speculate on. I cannot tell you yes or no. I cannot tell you the judge is going to agree. I cannot tell you the judge is not going to agree. So that is why I said that question is not a question I can tell you, yes, you are right, or no, you are wrong. It's not a yes or no answer. You may see some lawyers come to court representing ICE, defend the case, present the case, and not talk about false claim to USC. You may see some other lawyers who will come to court and make that a big issue, pointing to the judge why you are not a person of good moral character, because you are falsely claimed to be a US citizen. So these things are not something we can predetermine, because even the ICE lawyers that will represent you, that will prosecute your case in court, they are not predetermined. The system here is completely different. It's not like some African countries where some of us come from. The system is so regulated and is organized in a way to avoid corruption. So, even if you are Mr. A's friend and Mr. A came to court today to represent immigration, at the next adjourned date, the next date that you are going to be in court, you may not have Mr. A in court. It may be Mr. D who will show up representing immigration. So if you have discussed anything with Mr. A, that discussion, especially if it is something that is not 100% legal that you can put into the record, that discussion may be invalid. So it depends on who is. This is where element of law comes into play. And also, this is also where having a good immigration lawyer also come to play. Because again, if, for example, I am representing you, I will look at the totality of the case. Why did you falsely claim to be a USC? Did you claim to be a USC as a result of the abuse, or was it a consequence of the abuse? There are so many things that has to be considered. Was it a consequence of the abuse? Maybe when your USC spouse was abusing you, you had to run for your life, and in the process, you had to lie that you are a US citizen in order to get help that you need. If those are some of the things that the court is going to consider. So if your lawyer adequately represents you, it is your lawyer's duty to present all those arguments in your favor in court. Then secondly, falsely claiming to be a US citizen, for what purpose? Because even though it's a blanket bar, but again, you have to look at the purpose. Because the law states for the purpose of obtaining a benefit. So the question is, what constitutes a benefit? Let me give you an example. Maybe you falsely claim to be US citizen out of mere puff. Maybe something you just did to boost your ego. Not because you wanted any benefit, but just to boost your ego. Oh, you know what? I'm a US citizen. I'm using American passport. Maybe it's something to boost your ego. If that is the case, what benefit are you getting? So that cannot disqualify you because you didn't falsely claim to be a US citizen in order to receive a benefit. There are a couple of arguable cases of false claim to US citizen. For example, someone who falsely claimed to be a US citizen in a mortgage application. Is that considered a benefit? It is arguable. The question is, if you are not a US citizen, will you have been able to receive a mortgage? If the answer is yes, you can argue it that, look, this thing didn't give me any benefit. I know people who don't even live in the US who still buy houses on mortgage. So there are so many. You see, immigration law generally is a complex and interesting scenario. It's a very, very interesting area of practice, area of life. So get a good lawyer and you can argue your case. So that's why I cannot tell you whether, yes, you are right, you can be disqualified or you cannot, but I will tell you it is arguable. Next question. I was married to an LPR, but his own green card was rescinded after we divorced. If I'm otherwise qualified, can I apply for cancellation of removal for victims of violence? Yes. Yes. If at the time of your marriage, if he was a permanent resident, you may be eligible to apply for cancellation of removal. However, there is a caveat. I need to state this very clearly so that I'm not misquoted. There is a caveat. You cannot build something on nothing. If the reason his green card was rescinded was, for example, because he obtained it by fraud, maybe by fraudulent marriage. If you are one way or the other, directly or indirectly connected with that fraud, you will not be eligible for cancellation of removal. Let me expatiate that. This is just an example. Let's say you and your spouse, maybe you are previously married in Africa, for example. You came to the US submitted or claimed to be divorced and went your separate ways. Your spouse married a US citizen who files a petition for him or her, and then your spouse obtained the green card. Maybe along the line, immigration found out. Remember, this is just hypothetical. Maybe along the line, immigration found out that the purported divorce document is fake. And then they resigned the green card. Now, before the green card was resigned, you remarried him and then later divorced him. Then his green card was resigned. Are you eligible for cancellation of removal? The answer will be no. Because if the initial divorce was not valid, that is a connection. That has a connection with you. So that you cannot benefit from that fraud. You cannot, because you cannot build something on nothing. So you cannot benefit from that fraud. But if this is a completely independent marriage that has nothing directly or indirectly with the fraud or with whatever led to his green card being resigned, then you can still be eligible irrespective of the fact that his green card was resigned. The reason I keep using the word fraud is that, to the best of my knowledge, the only reason a green card could be resigned is if it was obtained by fraud. That is the only reason. There's no other reason. Even if a green card holder committed a crime, green card cannot be resigned for that purpose. Green card can be the green card holder can be placed in removal proceedings, and then the green card can be taken away, but it cannot be resigned, because resigning means that he voids whatever benefit that he is supposed to get as from being a permanent resident. So the only time a green card can be resigned if it was obtained by fraud. The same thing with citizenship. The only time citizenship can be resigned is if the applicant obtains citizenship by fraud. That is the only, even if it's a US citizen committed murder, which is probably one of the highest offense anyone can commit. If a US citizen turned to a terrorist or whatever offense, citizenship cannot be resigned. The only time it can be resigned is if it was obtained by fraud. Same rules for permanent resident. The only time a green card can be resigned is if it is obtained by fraud. So if you do not have any connection directly or indirectly with the fraud, yes, you can apply for cancellation of removal. But if you are linked either directly or indirectly, you will not be eligible. The next question. Please keep the questions coming. We have about 12 more minutes to go. We'll try everything possible to answer every question before we leave. So we have about 12 more minutes to go. And remember to join us every Wednesday, 12 p.m. Central Standard Time. Remember to invite family and friends. Remember to also subscribe to our channel so that you will be notified when we go live. Also, remember, we handle personal injury cases if you are involved in any form of accident, auto accident, slip and fall, medical malpractice, any form of accident. Contact us and we will help you with adequate compensation. Now, next question. I am now a permanent resident that I got through VAWA cancellation of removal, but I'm now back with my abuser. Can my status be affected? I want to apply for citizenship. Well, this question is not, I will need more clarification. When you say you are back with your abuser, does that mean that you remarried or you are just living together? Because it will have effect. It will affect my answer. So if you can clarify this, whoever sent this question, if you can clarify it, I will be happy so that I don't mislead you. I don't give you the wrong answer. Please clarify it so that I can give appropriate answer. So, are you back together by just living together, or are you remarried? Because the reason is, number one, for the purpose of citizenship, if you are a victim of VAWA, you are required to be a permanent resident for 3 years, not 5. So if you are a victim, you are only required to be a permanent resident for 3 years. So, did you remarry this person, or are you just living together? If you are just living together, it may not affect your citizenship application. But if you are remarried, during your citizenship, questions may come up as to whether he or she actually abused you. Questions may come up, but it may not disqualify you, but questions may come up. But the most important thing is, will you be eligible for citizenship if you are remarried in 3 years? I don't think so. I'm not 100% sure. This is a very novel question that I've never thought about, and I've not handled that area before. But I can look into it and come back to revisit this question next week. If whoever sent this question, if you are listening, you can remind me next week. I promise to look into it and address it. It's a novel question, but based on my experience, I don't think you will be eligible for citizenship in 3 years if you remarry the abuser. But again, I'm not 100% sure. I will look into it and confirm. I'll verify it next week. Remember, nobody has a monopoly of wisdom. I'm not an encyclopedia. So it is not every question that I may be able to answer right on at my sitting here. So this is one of those questions that I will need to look further into before I give you the appropriate answer. But I doubt it if you will be eligible in 3 years if you remarry the abuser. But again, I will have to check. I will have to confirm. So I will have to see what the law says about that. When I say confirm, I'm not going to Google. I'm not going to do all that. I'm going to look at the law to tell you what does the law say about that situation. So we'll get back. Please note it and remind me about that question next week by God's grace. The good thing is that next week we are still going to be discussing cancellation of removal, but this time we'll be discussing cancellation of removal for legal permanent resident. So we will address this next week by God's grace. Next question. Next question. My I-130 that my spouse filed for me was denied based on the Adam Walsh Act. For this I-130, I wrote a letter stating I knew about his charges and past behavior, but that I love him and how he has changed. Can this letter be used against me if I file with any type of VAWA? No. That cannot be used against you, because you see, one thing, when we are talking about abuse, we are actually talking more about manipulation. Most abusers are very, very manipulative. So for somebody to get you to even write this letter may be part of the manipulation. So that's not going to affect you if you are otherwise eligible for VAWA. It's not going to affect you. But if you are not eligible, yes, that's a different ball game. But if you are otherwise eligible, the fact that you gave him this letter is not going to affect you, because manipulation is actually one of the factors to consider when they are adjudicating abuse, VAWA cases. Next question. Okay, clarification on the above. He had not really changed and was emotional abusive and controlling. He kept pushing for the I-130 and I was not being 100% truthful in the letter. Oh, okay. It's a follow-up to the one I just answered. Yeah, like I said, the letter is not an issue for as long as you met other requirements for VAWA. The letter will not disqualify you. Come to think of it, if you really love somebody and the person is in trouble, you will do whatever you can to help the person. So that's not something to be used against you at all. It's not something to be used against you, and I can assure you it will not affect anything. Okay, keep the questions coming. We have 5 more minutes to go. Remember, we do this every Wednesday, 12 p.m. Dallas time. That is 12 p.m. Central Standard Time. That is 1 p.m. Eastern Time. That is 10 a.m. Pacific. And that is currently 6 p.m. Nigerian time. Calling from all over the world, wherever you are, sending your questions ahead of time, sending your questions during our podcast. We have a dedicated line that you can contact us on, either regular text, either WhatsApp, or either voice call. That number is 817-883-4495. 817-883-4495. It's a dedicated number. You can send your question ahead of time. Like we have said, we started last week removal defenses, and we started with cancellation of removal for non-permanent resident. Today, we discuss cancellation of removal for victims of abuse, and next week, by God's grace, we are going to be discussing cancellation of removal for legal permanent resident. So you can send your questions ahead of time. If you have your questions, send it ahead of time. That number is a dedicated line, 817-883-44995. It doesn't matter what time you send in your question. Whenever we get to the office, we will receive your question and we will answer it during the live podcast. So remember to invite family and friends. Don't be selfish with this information. We are doing this free of charge, and it will be unfair on your part if you are getting it and you are not sharing with family and friends. So share with your friends, share with your family, so that next week they can also join us. And if you missed today's episode, you can always go back to our YouTube channel for a replay. You can listen to all the questions that were asked today and also all the answers to the questions. So you can do that. We'll appreciate your tuning in. Subscribe to our channel so that whenever we go live, you can be notified. Okay, questions are still coming in. We still have a few more minutes. If you have questions, you send it in. Any question that we receive before 2 p.m. Dallas time, we will answer it, even if it means extending beyond 2. We will answer it. So the next question. Will an approved cancellation of removal for victims of violence mean that I am a permanent resident and I will get my green card, or do I still have to file adjustment of status? Yes, cancellation of removal is actually an adjustment of status. You file it concurrently with adjustment of status. So if it is approved, you are granted legal permanent resident. You become a permanent resident on the day of the approval. So if your cancellation is granted, that means you are a legal permanent resident of the United States. So it's not a separate application from adjustment. It is a simultaneous application for adjustment of status. So you become a legal permanent resident of the United States. So that is the last question we have for now. Again, okay, it's like this person is checking the time. Okay, I promised any question we receive before 2, we will answer before we go, even if it means going beyond 2 p.m. Okay, question just came in. Can I get benefit for VAWA cancellation like I can with regular VAWA? What do you mean by benefit for VAWA cancellation? Well, if I understand this question correctly, I know that when you are talking about regular VAWA, they give you what is called prima facie determination letter, and you use that letter to obtain benefit, to do other things, even to show as evidence that you have a pending case. Unfortunately, there is no such thing in cancellation of removal for victim of abuse. The court, like I said, this is not USCIS. The court does not grant prima facie determination. The process does not even involve things like that. In a cancellation of removal for victims of abuse, you submit your application to the court, and then the court will set a hearing date. So on the hearing date, you present your evidence, you present your testimony. Your lawyer will present what we call examination in chief. The opposing lawyer will cross-examine you, cross-examine your witnesses, and then the judge will make his or her own ruling and determine your case. So there is no opportunity for prima facie determination. There is no opportunity for temporary benefit and all of that. So it is either your cancellation application is granted or is denied. And if it is denied, you have a right of appeal, because the immigration judge's decision is not final. So if it is denied, you can appeal to the Board of Immigration Appeal. And even if the BIA, the Board of Immigration Appeal, if they deny the case, you can still appeal further to circuit court. So with that, I believe we come to the end of today's program. Again, remember to join us next week and every Wednesday, 12 p.m. Central Standard Time. That is our time. Remember to invite family, friends to join us at every time. Join us again. Thank you, and subscribe to our channels. Bye. Another interesting thing about our office, we try as much as possible to put smiles in our client faces.
As soon as we call that client, it's such a great feeling. I mean, at first when we're pranking them, I feel so bad.
I was coming from work because like I told you, I'm like a member of this family, and call Asekun, he wants to talk to you.
There is a strategy that we like to do. We like to surprise them. We would call and Mr. Olu would talk to them, letting them know, well, maybe something has gone wrong with their case.
He made it look as if there was no approval. But then I was okay, I'm coming to your office. He said, okay, but just drive carefully and it is like that. So, okay, I'm waiting for you. Then when I came into the office, even the receptionist, her face was just blank. What is happening? He said, okay, let me tell him that you're around. I went to the office. He had already assembled the entire staff. And when I came in, wow, the balloon just busted. When he said, well, this is what, he made it look as if it was going to be like, and then he now, congratulations. He didn't say you were approved, he said, we have been approved.
They get so excited, they're happy, they start crying, they're just super excited. I had times where I cry with them because you feel what they're feeling. And you understand what they go through, and it, like I mentioned, like we all handle their case, we all know their cases, and it's like I am one of them, and I understand what's going on, and I'm happy for them that it's finally ended and they are now where they want to be. That is our main goal.
And I jumped. I didn't know how or where the strength came from. I didn't even think I could knock him down. I pared his neck because that particular issue was so naughty. But God just used him and everything was resolved and I got my approval. The entire office, they were so happy, they were jubilating as if it was one of them or their own child.
Having someone go from a super low to a high of something, such a positive result, it feels amazing, honestly.
It's really, really a big challenge. But again, we were able to put smiles in her face and we were able to get her substantial amount of money from the insurance company. Even after paying all her medical bills, she was able to smile to the bank.
Our clients love us because we care. Their experiences are our experiences. Their joy is our joy. Their sorrow is our sorrow. So we really, really care about everyone that walks through those doors. And I think that that's what makes us special.
And then I rolled on the ground. All of them, I was, Nigerians, how we react to issues. I was rolling on the ground, thanking God. Is that not caring what I was wearing or who I was looking? But the good thing is that the entire office was happy with me, not for me, because they felt that it was their win, it was their own, and we all celebrated. It was a good thing.
Let's face it, if you or your loved one has been wrongfully injured by the negligence of another, it is important to retain the most reliable personal injury attorney possible. At the Law Office of Olu Asekun PC, our dedicated team of attorneys, comprising of Dr. Olu Asekun, Texas and New York licensed, Ya Adubafor, Texas licensed, Jane Asari, Texas licensed, and Olusegun Asekun, Missouri licensed, will fight for your rights. Whether your injury was the result of an auto accident, slip and fall, wrongful death, or medical malpractice, we offer representation on a contingency fee basis. That means that if there is no recovery, you pay us nothing. Contact us on oluasekun.lawyer to know more, or call, text, WhatsApp our office at 817-891-6655. 817-891-6655. Let's face it.
I was looking for Lawyer Asekun for help concerning my immigration status because everything was upside down. Because I couldn't believe, I was even thinking maybe I'll be sent out back to Nigeria. So on getting to know him, he explained everything to me, what I'm going to do, that he's going to do everything. So fortunately for me, everything was done from him. Dr. Lawyer Asekun is the best lawyer so far in Texas, because I can introduce as many as whoever is having problem, especially when it comes to immigration. I'm going to introduce Lawyer Asekun because he's the best lawyer. So far, so good.
Our goal here is to make our clients happy, especially in the area of immigration, family law, and personal injury.
The principle was that it was a man that you can rely on. They work with me, they work with me like, it became something like family, right? It was no longer like, okay, this is a client, this is somebody you are providing you service, right? So it became something like a family. So yeah, I can see the relationship was good, working with his staff. People give me encouragement, but I will look at it and say, how is it possible? I said, it is not going to be possible. That's why I kept telling myself that it's not going to be possible. But he knew what he was doing. Like I said, research is very, very important. If you do research, you will learn a lot of stuff. There are a lot of immigration rules some people don't look at. There are loopholes there, and sometimes they purposely put them there. So it's research, and it's using those research to help a lot of people, not just me. It is not just me. It is a lot of people here many people here that he has helped. Many people. Sometimes it doesn't even charge them. When it comes to the point that it doesn't even charge them. So yes, if you are looking for immigration lawyer. You know, even if I'm sleepy right now, if I'm like sleepy, you wake me up, you say, do you know any immigration lawyer? I won't even blink, you know. I will say it, Dr. Asekun is there, you know. I will just say it. So, yeah, that's how good he is.
Talking about immigration, as an immigrant myself, I always put myself in the shoes of clients because I've passed through the immigration process and I know how hard it can be on people when they don't have the legal documents to work or to do day-to-day activities here in the United States. So that personal touch makes a big difference.
The law office of Olu Asekun is special because we like to put ourselves in our client's shoes.
For Dr. Asekun, for me, I will forever be grateful, and I keep telling people he's the best immigration lawyer you can have. You know, he's the best immigration lawyer you can have.